Good morning, WTOB listeners. This is For the Record with Greenwood Law. Thank you for joining us this morning. I'm Harold Eustache along with Dylan Greenwood. And today we're going to be talking about all the things that happen in a jury trial. And there's been so many just famous and important jury trials that have happened in our country's history. And, it seems like we're always every year going through an important jury trial. And there's one that's ever present in the news today. And we thought there's so many interesting issues going on in that case legally that we thought it'd be good for us to talk about and walk you guys through how a jury trial works and some of these terms that you'll hear coming out in this case. This case we're talking about is a case where the victim's name is Ahmaud Arbery. It happened in Georgia, and there are three defendants. Two of them are brothers and another man, and they are accused of murdering Mr. Arbery. They are not police officers. They are private citizens, and there's a lot of factual things in this case that I think people know about. But right now, what's happening is a jury is being selected. So I think they're in the second day of jury selection today, and we wanted to just kind of walk through that process of how a jury selection and all the stuff that people are going to hear about in this case that is very likely to be on the front page and ever present in the whole country's mind. So, right now, the issue that they're having is trying to select the jury. And so a lot of times you hear, well, you can't taint a jury pool, or they're asking about whether or not people know about a case. The standard really isn't that somebody doesn't have to know anything about the case. That'd be tough to find, especially in a case like this, in a county that small in Georgia, that nobody's heard of it. The standard is really, can they be impartial? Can that juror really hear the evidence only take the evidence presented by the prosecutors in that case and listen to everything that's presented and all the defenses by the defense attorney, if there are any, and make a determination based only on the evidence that they hear. And that's the challenge for going to be for them.
Right, because at a jury trial like this, a jury, the 12 people in the box, they are the triers of fact. It's their job to figure out whose testimony is credible, who to believe, what the facts are in the case, and then apply those facts to the law as it is presented to them from the judge. And so that's why members of the jury don't stick around for objections that involve arguments between the attorneys. Mm-hmm. They are not around for conferences that occur during the course of a jury trial among attorneys and the judge and whatnot, because those things could potentially taint that jury pool, because it doesn't want to be ever construed that the jury basically picked the winning side because they thought one lawyer was better than the other. And so before a jury is ever selected, that's why pretrial motions and stuff that get filed are heard first.
What are some of those pretrial motions that?
So some of them that are common are motions to suppress, which we've talked about plenty of times on this program, where basically you're saying the law enforcement officers usually messed up in some way. Either they got statements from somebody they shouldn't have gotten, they've gathered evidence somehow or another that they shouldn't have had access to in the first place, and that should be suppressed. That should not come into evidence. Some other common ones are something called a motion in limine. Mm-hmm. Motions in limine are issues of which the attorneys are looking forward, literally looking into the future, potentially on with the trial, and saying, we believe this is going to be some sort of evidentiary issue. Let's make a determination on it now, so that when it comes up to that moment in trial, the attorney on the other side already knows they can't go down that path. The reason why you do that is, the way I always think about it is, you can't unring a bell.
Right.
And so, many times over the course, and it's a tactic we as attorneys use in all candor, that, you ask that question knowing, it might get objected to, and that objection might get sustained, but at the end of the day, the jury heard you ask that question.
Right.
And they're going to be wondering about the question you asked.
And so part of what these attorneys are trying to do in these trials is like Dylan said, forecast what's going to happen. It's part of our job as attorneys to use our experience and knowledge to be able to look at the potential issues in the future and start keying in on those. Right now, what they're doing is picking a jury, and that process is called voir dire. Can you tell us, we talk about how voir dire
so
works?
the term voir dire is used throughout the legal system. Most commonly, though, it's used when it comes to jury selection. It literally means you're asking a lot of questions to try to figure something out. I mean, that's just the plain, simple version of it. So what it is you've got questions that are asked by each attorney. There are a series of questions asked by the state. There are a series of questions asked by the defense counsel. And in the course of that, you're trying to determine whether or not a juror might have some sort of bias. If the bias is strong enough, a juror can get stricken for cause, which means that you go before the court and say, listen, this juror has made it quite clear that they look at police officer testimony above everyone else's. There is nothing that a police officer could say that is not true to them. That's a bias. Because you as a juror are supposed to treat every single witness, every single piece of testimony the same until it's your time to determine the credibility. If you go in initially thinking that some people are more credible automatically because they have a badge, you have a bias. And so that's a potential reason that you could be stricken for cause. Each side has the ability to use what are called preemptory challenges to strike people because they, for whatever reason, except for race, ethnicity, nationality, sex, that sort of thing.
And it becomes this, and especially in a case like this, really in any case, it becomes such an important issue. I think in looking at, in this particular case, in the Arbery case already, I think 40 or so jurors have been called, potential jurors. None have been impaneled yet. And there's already some back and forth in the media of the number of white and black people have been excused, because this is something that we know as attorneys comes up on appeal in a Batson challenge and can be very, very important to what happens in the case. So it's definitely something that is present on our minds, because even though you have these preemptory strikes where you can strike somebody just because you just didn't like them, you got a bad feeling about them or whatever, it still has to be, you still have to be able to back that up later.
And because they're not, they are limited.
Right,
each side only gets a few of them.
Right.
And those rules are different in state court versus federal court too. Sure. In fact, the other difference is that in federal court, the judge asks the voir dire questions, not the attorneys. Because in state court, our job as an attorney during voir dire, we like to get to know the jury. Like to get that conversation going, like to start to lay the foundational blocks of what we feel like that case is going to be about. Where people in the jury already start thinking, well, why are they asking me this? What could this be? And trying to get a sense of how people feel about certain aspects of the law or people or subjects. How do you feel about people who use substances? How do you feel about, it's that type of thing. And you do that through a series of questions. And really that series of questioning it's a bit of an art.
It really is. No, it really, really is. And I think a lot of it's just a whole art to picking juries. Some attorneys feel like sometimes there is no art to it, in a sense that it's just so random. But once a jury is selected, which can take time. I think in some of these big cases, it may take weeks.
It should take time.
It should take time. It's one of the most, literally, it's very, very important to the entire trial. But once that jury's impaneled and they're sworn in to be jurors, that's when the meat of that case starts, and it starts with opening statements. And opening statements are important because, that term statement just is important. It's not an argument. It's an opening statement where both sides, if they choose to, have the opportunity to forecast what's going to happen. and what the jury will hear in that case.
Right, and there are rules as to how attorneys can conduct themselves during opening statements. And opening statements can actually be objected to. They can be appealed. There's reasons or things that come out in an opening statement that you can appeal because someone went too far during an opening statement. You can't go out there and automatically refer to people that are going to come up in the trial as liars. Mm-hmm. You actually just cannot say that word.
Right.
There have been plenty of court cases that say that attorneys, you just can't say that. You can get around that other ways through some linguistic gymnastics, mm-hmm. if you will, but you can't just outright do that to somebody. The opening statement, the purpose of it really is to start the story. To foreshadow or forecast what the story is going to be, because really a trial should be a story. Right.
And that's from that opening statement goes into in a criminal trial, the state putting on evidence. In a civil trial, be the plaintiff, but we'll leave it at a criminal trial for now. It's the state putting on this evidence, and when somebody hears that, they might think, well, what's going on there? And they think, a lot of people, I will say, when they come into trials, they think, there's the prosecutor and there's the defense attorney, and they've all got to, battle it out to see who wins. That's really not what's happening in a criminal trial. What's happening is the state has a burden, and that burden is beyond a reasonable doubt. It has to prove to the finder of fact, that's the jury, that whatever the allegations are, and every element of those allegations happened beyond a reasonable doubt. So the state is presenting this evidence, and generally they're presenting evidence through testimony, through direct testimony from a witness who is sworn in. And it's important on that direct testimony that the state asks these open-ended questions to tell that story that Dylan was talking about from the opening statement. So kind of how that looks is the state will call a witness. Let's say it's a law enforcement officer or a detective, and that detective will go through the story of their investigation, what happened. And really the way that we think about it as lawyers is when the state is putting on evidence and a detective or whoever their witness is testifying, the light is kind of on that witness. That's where the story is being told. And we'll get to later, I think Dylan can talk about where the light is if a defense attorney mm-hmm. is talking. But, it's up to a prosecutor to ask these sort of open-ended questions. Well, tell us what happened on October 10th, 2020. Where were you? And so these open-ended questions where a witness can explain what happened. It's important in the back and forth that not be leading. And that's where right. We get to where after that direct witness testifies, they have the opportunity to be cross-examined.
Right. And the way I think about direct is the prosecutor is basically like a journalist mm-hmm. interviewing somebody, and instead of you, the juror, reading what's in the newspaper that the journalist wrote, you're basically on the scene listening firsthand to what the questions that the journalist is asking the witness. Because it is who, what, when, where, why. Mm-hmm, mm-hmm. And, it's important to establish those dates because that burden of proof beyond a reasonable doubt, I think it's worth reiterating, Harold. Each and every element has to be proven beyond a reasonable doubt.
Right.
And, when that doesn't happen, and you get hung up on one of the elements, you may look on the surface and think, well, yeah, this was wrong. But if it doesn't tick every box, then it wasn't a violation of the law.
Right.
Because that's how we've set it out. So I do think it's important that, and one of those aspects is specifically the date it happened, where it happened, because all that stuff is listed in a charging document. And mm-hmm. we've talked on this program before about different charging documents.
Yep.
And if the state does not prove what is on that charging document, then they've potentially violated somebody's due process because they've proved something else happened, not the person that the person is on trial for mm-hmm. that day before that jury.
Right. Well, and so after the prosecutor, gets out this story on direct,
yeah,
you can have a defense attorney cross-examine them. This is something that we do all the time as defense attorneys. We cross-examine people. And it's one of those terms that you hear out there all the time, not just from trials, but just in life about cross-examination. So how does that work, and why do we have the right to do it?
So cross-examination, we have the right to do it because of our Constitution. Confrontation clause of our Bill of Rights, the Sixth Amendment, says that you have the right to confront and cross-examine witnesses. And the reason why is because way back in the day, you would just have some witness that would come in, make the accusation, and then boom, that was it, guilty, take them out back. We determined in our country way back when we first started that was wrong, that you should have that right. In fact, it actually goes back further than that, to Magna Carta type days. But still, it's important to be able to talk through, because witnesses come in with different motivations for why they're there.
Mm-hmm.
Witnesses come in potentially having given inconsistent statements. Witnesses come in with a lot of issues potentially related to competency for them to be able to testify in the first place.
Mm-hmm.
And, a low-hanging fruit on this that's, easy to point out, and one that comes out on cross-examination is the guy in the jailhouse that becomes friends with the accused individual, acts like they found out some stuff, tries to relay that information to the state in order to get a better outcome in their case. Well, there's a bias there. Mm-hmm. There's a motivation there. And on cross-examination, you can get that out potentially, hopefully, through that cross-examination, because defense attorneys during cross-examination, or any attorney during cross-examination for that matter, are not bound by that who, what, when, where, why form of questioning that direct is. You can lead a witness on cross-examination.
In fact, it's encouraged you lead a witness.
Absolutely, because you're asking yes and no questions. And essentially, as the attorney doing the cross-examination, you're more or less testifying for the other person.
Right.
Trying to highlight areas in which their statements were inconsistent. That's called impeachment. And if one of the goals of cross-examination is to try to impeach a witness, to show that they are not credible. Because again, one of your jobs as a juror is to determine credibility.
And so for our audience, think about just from a practical standpoint. You have these people, they're being sworn in, and a lot of what happens is about the testimony of a human being, them swearing under oath that they're going to tell the truth. Well, like Dylan's saying, a lot of the trial is, can this person's testimony really be trusted?
Yeah.
Is there bias? What's the trustworthiness of their testimony? And that comes out, and that can be challenged on cross-examinations and impeachment, through impeachment. So all that's super important.
And I made it sound, somewhat, that people are trying to do shady stuff in court. There are witnesses that come in that reasonably believe that they have seen something that they've seen. But when you're able to pull out on cross-examination that whatever they viewed and they're testifying to, they were 100 feet back from the car in the middle of Stratford Road, and they were looking through a tinted back window, so they only got a sliver or something, and they're trying to tell a jury that they saw plain as day that an assault occurred, and they know exactly who hit whom and all this stuff, and you're going, okay, that's a long way away. You're trying to drive at the same time. Mm-hmm. You're looking through a tinted window, and you're able to tell blow for blow who did what to whom. That there's just no way that that is going to be highly credible, because I think most people would look at that and go, how'd you see all that?
Right. And as a juror, you're allowed to use your own common sense when making rendering a verdict. Ultimately we get to, but you're allowed to use your own common sense and your experiences in the world to come to a decision about that. So a defense attorney challenges and says, hey, this is so far away. You're allowed to think, okay, to think about that. So after the state puts on that evidence, what happens next generally?
So generally, after the state puts on its evidence, defense attorneys have had the chance to cross-examine all the state's witnesses. Then the state will close its evidence. And at the close of evidence, attorneys typically make a motion to dismiss. And at a motion to dismiss, what the defense attorney is trying to say is that even in the light most favorable to the prosecution, if you look at everything that came out and what it could be, that there's no way the state could meet its burden.
And this is done outside of the jury.
Outside of the jury pool. And sometimes cases win on that, because if you haven't ticked all the boxes on every element, which is what you have to do, and there's a determination of that by a judge.
The jury couldn't even make a verdict on one of these elements because there was no evidence presented or something like that.
Right.
Then you would potentially win that kind of motion.
If you're just joining us here on For the Record with Greenwood Law, I'm Dylan Greenwood here with Harold Eustache, and we've been walking through different aspects of a jury trial. Jury trials, famous ones, pop up in the news all the time. And you hear a lot of things that happen, like jury selection and direct examination, cross-examination, all these different terms that come about. Well, how does that actually work, and how that actually plays out is something that can have a little bit of a mystique to it. And so we've been trying to sort of break that down so that you all can know a little bit more when you hear about this stuff in the media. And what we have been talking about is the different aspects of this all the way through. And I think one important thing that we need to touch on is objections that happen in the midst of a trial. And they can happen whether the state is putting on evidence, whether or not the defense is putting on evidence. But basically, when an objection happens, an attorney, the opposing attorney, is objecting to the court as the trier of law and saying that whatever is about to come out into evidence, or what we think is about to come out into evidence, violates one of those rules of evidence. So let's say somebody is starting to talk about what they heard someone else say. Well, our rules of evidence say that the person who made that statement should be the one that comes into court more often than not to make those statements.
Right.
I'm not going to be the one to testify to what someone else said. That's called hearsay. Now, again, there are plenty of exceptions. The thing about the law is there is exceptions to the exceptions to the exception. But generally speaking, that's one of the main objections that happen.
It is, these are evidentiary things that it's on the attorneys. It's really on them. The objections don't happen but for attorneys knowing the rules of evidence. And so
sometimes it's a strategy thing.
Oh, absolutely.
Of whether or not to object.
Whether or not to object because of how it looks in front of the jury, to preserve things on appeal. There's all sorts of issues with objection. I know in this trial we were talking about earlier before the show, there's a really interesting evidentiary issue about the Confederate flag being on the front of one of those defendants' cars.
Right.
And the issue is, can that flag come into evidence?
Right, because it's potentially prejudicial. And one of the things that you worry about as a defense attorney is whether or not evidence that would come in is prejudicial to your client. And you're trying to determine if the probative value of the evidence outweighs the prejudicial value. And that's a big potential issue. I think it's important to note that on objections, as a juror, every now and then you see somebody's notes about, they're kind of make little check marks as to which attorney won which objection when. And I think it's important to know that just because an attorney wins or doesn't win an objection, it isn't a mark as to whether or not they're good at being an attorney or whether or not their case is being successful or not. Again, there's plenty of reasons why you might object or not object. But in the midst of all that, once the state does its evidence, you got all these motions, the defense has its time to put on evidence as well.
But they don't have to.
But they don't have
That's
to.
one of
That's
the
a
important
constitutional right.
Right.
That you don't have to do that.
And so it's important, even in going all the way back to voir dire. I think any defense attorney, at least a decent one, is going to make sure that a jury understands. You understand as a juror, it's okay for a defendant to be presumed innocent and not put on any evidence, and that can't hurt that person. They don't have to prove anything. It's the state that has to prove something in a criminal case.
Right.
So.
And so at the end of all that, you've got closing arguments, and closing arguments are where this big summation of what you've just heard, how it could apply. It's a bit argumentative. It's more argumentative than the opening statement. You're able to talk a bit about, well, you heard this, this, and this, and the judge has asked you to apply the law. Here's how that looks like it applies. You're allowed to. You can't be argumentative, but you can be. You can advocate. You can advocate for a position. You can advocate for, looking at credibility a certain way. You highlight all the things that you want that jury to pick up on through the course of the trial. And so, that can sometimes cases can be won or lost in closing statements. I tend to think that most cases are won and lost in voir dire, in jury selection.
I do too. I think most attorneys would think that. Well, we hope that we've been able to explain some of what happens in a jury trial. I mean, there's actually a lot more that we could unpack here. This was really a crash course. We hope this has been interesting to you guys. So we thank you for joining us on For the Record with Greenwood Law. But before we go, Dylan, can you?
Yeah, that Greenwood Law Bill of Rights, don't forget it. First and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. Third, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. Everybody stay safe out there. It's not a crime to know and assert your rights. This is For the Record with Greenwood Law, signing off.